Hi everyone, it's Marlene Alphonse. Welcome back to my channel and welcome if you're new. I go over tech information, specifically cybersecurity related information and the intersection between tech and law, and we go over these tech topics, figuring out where lawyers or cyber attorneys like me and potentially you fit in the mix. Today in this video, we are going to be performing a deep dive into the 2026 incident response lifecycle. We'll examine how the new NIST 861 revision 3 standards have transformed IR incident response from a reactive IT ticket into a high-stakes hybrid of digital forensics and legal warfare. By the end of this video, you will understand the Submarine doctrine of containment, how to protect forensic evidence for the courtroom, and exactly where the rules in the cyber analysis and the breach counsel mesh. We'll break this down into 4 modularized phases aligned with the NIST CSF 2.0, and we'll be going over why peacetime planning is now a legal mandate, the 4-day SEC clock, technical sandboxing, and the prevention of volatile memory, as well as the clean room standard and the hot wash privilege. The first phase is govern and prepare, which is the strategy. The concept here is to have governance over your preparation. In terms of the tech side, you'd be deploying automatic playbooks and AI-driven containment tools to lower MTTD, which is mean time to detect. And for the law side, you'd be establishing attorney-client privilege from day 0, referencing in the Capital 1, we establish why breach counsel must hire the forensic team to protect reports for future discovery. And the mesh is tabletop exercises. So tech simulate the attack, and then the lawyers simulate the regulatory pressure to ensure both teams speak the same language before a real crisis hits. For the sake of research and a deep dive, let's go more into questions you might have about this phase. For example, what are automatic playbooks? Okay, so a manual playbook is a step-by-step PDF or the procedure. In an automatic playbook, it is a pre-programmed workflow executed by software, usually a SOAR platform, which stands for Security Orchestration, Automation, and Response. So automatic playbooks use conditional logic to connect different security tools. Instead of a human analyst manually logging into 5 different systems, the playbook does it at machine speed. The trigger would be a SIEM alert or suspicious login from a foreign IP. The action would be that the playbook automatically enriches the data by checking the IP against threat intelligence like VirusTotal, verifies the user's identity by cross-referencing HR records, contains the threat by disabling the user account in Active Directory, and notifies the on-call analyst and drafts an incident ticket. Love that for us. So what is SOAR and XDR? In 2026, these playbooks are primarily built using low-code or no-code editors, allowing analysis to drag and drop nodes or actions into a flowchart. The API integration. Playbooks rely on application interfaces that we discussed in my last video. Check it out. But in summary, API is just how you interact with a system, and they use APIs to tell the firewall to block an IP or tell the EDR to isolate a laptop. And then you have machine speed versus human speed. Of course, a manual response to a phishing email might take 20 to 30 minutes, but an automated playbook can triage, scan, and delete the same email from 5,000 inboxes in under 30 seconds. So a very big reason for utilizing the automated playbooks. Obviously, there are a couple of words in there that you may not understand, especially if you understand more so the law of things and not the technical side of things. So let's go over these main keywords, which are SOAR, SIEM, XDR, and EDR. So EDR is endpoint detection and response, the security guard on the laptop. It's a software agent installed directly on endpoints like laptops, servers, workstations, and it watches every process file change, and network connection on that specific device. If it sees a suspicious process tree, like Microsoft Word suddenly trying to run a PowerShell script to download a file, it kills the process and isolates the laptop from the network. For example, like if we had to use an analogy, a security guard stationed inside of a single room, right? They see everything happening inside that room, but nothing in the hallway. And what is SIEM? SIEM stands for Security Information and Event Management, the command center logbook. It's a massive database that collects logs or records of activity from everything like firewalls, EDRs, routers, and even the Office badge reader. It looks for patterns across different systems. If the SIEM sees a failed login on the VPN and then a successful login from a new IP in a different country 5 minutes later, it sounds the alarm. SIEM is your compliance engine, essentially, for the law side. Regulations like the SEC and HIPAA 2026 standards require long-term log retention. The SIEM is where you prove to a judge what happened 6 months ago. For example, think of the central security office in a skyscraper where all the CCTV feeds and entry logs are stored and analyzed. What about SOAR? SOAR is security orchestration, automation, and response, like the robotic first responder. It's the automation engine that bolts onto the SIEM or XDR. It uses automatic playbooks to take action without a human. If SIEM reports a malicious IP, the SOAR automatically orchestrates a response. It tells the firewall to block the IP, tells the email server to delete the related emails, and tells HR to lock that user's account, all in a matter of seconds. And then, of course, the law side of SOAR provides the audit trail. It provides the company acted with due diligence, my English, at machine speed. So what is XDR? I know we use that word without explaining it, but here we are. It means extended detection and response, which is essentially the integrated detective. The 2026 evolution of EDR extends its vision beyond just a laptop. Basically, it combines EDR, endpoints, and network data, email security, and cloud telemetry into one unified brain. It correlates data natively, meaning it can see an entire attack path from email to laptop to server to the cloud as a single event, rather than 4 separate alerts. And then the tech side of this would be that XDR is designed to reduce alert fatigue for analysts by doing the heavy lifting for connecting the dots automatically. And for us too, because now we have that information easier, simpler, all in one. For example, a high-tech private investigator who has access to phone records, bank statements, and street cameras of one suspect all at once. Isn't that neat? That's pretty neat. So simply put, EDR's primary focus is the local device. It is used for stopping malware on a PC, and it does this by proving patient 0 in a breach. Then you have SIEM, which is the log aggression. It is best used for compliance and hunting patterns, and its legal framework would be for long-term evidence for regulators. SOAR is automation, for saving time and standardizing IR or incident response, and for legal framework, it would be for providing a consistent duty of care. And then XDR is for unified visibility. It is for seeing the big picture of an attack straight through, and for the lawyers, we would focus on how it defines the full blast radius, or it shows everything that we need all at once. Actually, let's go over something else for phase 1. Let's go over attorney-client privilege. What does that mean? Attorney-client privilege is the single most important legal shield in cybersecurity. It is a legal doctrine that keeps communications between an attorney and their client confidential. Basically, attorney-client privilege is the right of a client to refuse to disclose and to prevent others from disclosing confidential communications with their lawyer. The goal is to encourage full and frank communication. If a CEO is afraid their admission of a security flaw will be used against them in court, they won't tell the lawyer the truth, and the privilege removes this fear. The elements, or the 5 C's, is communication, an exchange of information like email, talking, or text. Confidential is a must because it has to stay private. If you use CC, a third-party vendor, privilege is usually waived or lost. And client, the person or the company seeking help. The counsel is a licensed attorney acting in a legal capacity, which would be me or you. And then the counsel or advice would be the purpose must be for legal advice, not business strategists. So basically that just means that we're trying to, as a lawyer, we're giving them counsel or advice. The Kovel Doctrine. Lawyers aren't usually coders. Under the Kovel Doctrine, privilege can extend to third-party experts, like a forensic analysis, if they are acting as a translator for the lawyer. Okay. So if the company hires a forensic firm, their report is a public document. If the law firm hires the forensic firm to help the lawyer understand the hack, that report can be protected by privilege, which is why people like me and you might want to understand hacking ourselves so we can save our company the resource and the money. AI warning, US versus Heppner. A major 2026 deep dive topic, AI waves, privilege. If an IR team uploads a privileged log to a public AI like the basic ChatGPT or Gemini to summarize the attack, a 2026 court ruled that the privilege is now destroyed. So because you shared the secret with a third-party AI provider, it is no longer confidential, which makes sense. For reference, forensics, or specifically digital forensics, is the scientific process of identifying, preserving, collecting, and analyzing digital evidence in a way that is legally admissible. If incident response, IR, is the emergency room focused on saving the patient, stopping the hack, then forensics is the autopsy and crime lab focused on proving exactly what happened and who did it and how. There are 4 pillars of forensics, right? To a cyber attorney, forensics is only as good as its documentation, right? It follows a strict 4-step workflow. And the first one being identification, finding where the evidence lives. Is it hidden files, cloud logs, or volatile RAM? Then is preservation, ensuring the data has not been changed. In 2026, this is done using write blockers, which is hardware that prevents any data from being written to a drive. And forensic imaging, creating a bit-for-bit clone of the data. Then there's the analysis part, which is using tools to reconstruct timelines. This answers the who, what, where, and when of the breach. And then, of course, the reporting, which is the creating of a document that a judge can understand. Since we're already on the topic of that, let's talk about the chain of custody, or the paper trail, which is one of the most critical parts of forensics, right? In the law, if there is a single 10-minute gap where the evidence was left in an unlocked room or unchecked, or defense attorney will argue that the evidence was tampered with, right? And the judge may rule it as inadmissible. So in terms of tech in 2026, we would use cryptographic hashing like the SHA-256 to fingerprint the data. If a single bit of 1 terabyte drive changes, the hash will be completely different, proving the evidence was altered. And I was talking about that in my last video too. If someone were to have the information and it was hashed, it was essentially self-identifying, meaning that this hash proves that it is identical to what the information was, right? And if it wasn't identical, then it would show consequently in its hash. I probably didn't fully understand it in that last one, but at least now I understand it now. And yeah, it just means that it's self-identifying, that the hash proves that it hasn't been tampered with. It is an exact clone of the information of the plain English. Okay. Now we can move on to phase 2, detect and identify, or the smoke alarm. The concept here is the materiality trigger. Detect, XDR, or extended detection and response, and SIEM, correlation, to identify the salt typhoon style fileless intrusions, as an example. And then for the law part, we would have the SEC Rule 1.05 mandate. The 4-day clock doesn't start at the hack. It starts at the determination of materiality. So let's get a better understanding of what this means. So we already know what XDR means, right? Extended detection and response. We know what SIEM means, right? And we know how that correlates into the first step, which is govern and prepare, right? But how does it help us detect and identify? So we know that SIEM helps us do both, detect and identify, right, in a simple manner. And then XDR also helps as well with that. So for example, that is the tech side of things. But for the law, what is it, right? It's saying that there is rules that we can use in terms of the SEC rule, where the 4-day clock doesn't start at the hack. It starts at the determination of materiality, meaning when any part of it has first been implemented, any part of the and just so that I can have a better understanding and thus explain it better for you, let's make sure we do a little deeper dive of this. So the SEC Rule 1.05 found in Form 8K is the primary tripwire for public companies. To understand this rule, you have to separate the technical clock from the legal clock, right? So here's the breakdown. First, we have the 2-stage timer. The law creates a 2-step process to prevent companies from hiding breaches while giving them a small window to investigate. Step 1, discovery, which is the technical clock. You find out you've been hacked. The SEC requires you to assess the incident without unreasonable delay. You cannot put your head in the sand for 3 weeks to avoid the timer. Step 2, determination, the legal clock. Your team, Cisco, CFO, and legal sits down and asks, is this big enough that a shareholder would care? The moment you say yes, the 4-day clock starts ticking. Here's a crucial rule. If you decide on Monday at 2 p.m. that the breach is material, you must file your Form 8K with the SEC by Friday. Okay, so these are basically just windows of figuring out that you've got hacked, figuring out, is this severe enough that it is a problem, not just for us to handle and for us to know, but for our stakeholders, our shareholders to know. And then that's when your timer starts happening. So if let's say someone who was opposing you said, hey, you knew this was an issue, you just kind of hid it, and you argued, no, we didn't, they will most likely bring up this rule and ask for your documentation to see, did you actually follow this or did you not? So if you broke that 4-day window, they can reason without a good valid reason, the opposing side can reasonably convince the judge that maybe there was some malpractice going on here. But what does it mean to be materiality, right? In the legal standard. So materiality is not a fixed number. There is no rule that says if you lose 1 million, it's material. Instead, the SEC uses a reasonable investor standard. Quantitative factors like financial loss, cost of remediation, dip in stock price, or fines, and then the qualitative factors, which are often more important, like did the hackers steal intellectual property, like trade secrets and and such matters, right? So is the company's reputation permanently damaged? Did the breach expose a fundamental flaw in how the company protects data? Will this lead to massive class action lawsuits, right? These are all very crucial questions to answer. And then of course you have why the gap matters for tech and for the tech team, right? So this is important, like I said before, because these are their windows. They're windows for discovery, investigation, determination, and then of course filing, right? And if they don't do this effectively, they would have technically violated the rule. And of course, that would put them in bad legal standing. Let's move on to phase number 3, contain and eradicate. So the concept here is the submarine doctrine, right? On the tech side, you would have microsegmentation, like I covered in my last video. And this would essentially means you would use like L3 boundaries to isolate the blast radius without killing the entire business, right? And then in terms of the law, you would have evidence preservation, like FRE 902, using the postcard rule, means do not power off the systems, right? Preserving RAM or volatile memory is critical for forensic integrity, right? And then of course, this can be seen implemented in a case study, Windsor bomb v cyber attacks in 2026. If the IR team deletes logs during cleanup, they commit spoliation of evidence, leading to an automatic loss in court. Don't want to have that. I did cover segmentation in my last video, which essentially just means microsegmentation, where you would cut off you would separate certain parts of your network so that if one part gets infected or infiltrated, it doesn't automatically affect or easily affect all the other parts. So I think everything here is pretty spick and span. I guess we can go over the Windsor bomb v cyber attacks a little deeper, especially as a lawyer, you need to know these certain kinds of case studies. So let's do that, and then we'll move on to the next phase. Okay, in the context of Windsor bomb v cyber attacks, it represents a landmark shift in how the legal system treats the victims of a hack. While the name sounds like a suit against the hackers themselves, the actual legal significance lies in the third-party liability and forensic discovery ruling that emerged from it. So number one, the core conflict from victim to defendant. Historically, a company that was hacked was seen as a victim, right? But in 2026, this case solidified the doctrine that inadequate security is a choice, which we knew already, right? So the situation, Windsor bomb, or I don't know if I'm saying that right, or let's just say WB, a prominent law firm, represented a massive class of plaintiffs whose data was stolen from a tech conglomerate, right? The legal pivot, instead of just chasing the anonymous cyber attackers, the litigation focused on the gross negligence that I went over in my last video of the company's incident response, or IR team. And then the discovery bomb was that during the trial, it was revealed that the company's IR team had cleaned the infected servers so aggressively that they deleted the original logs and the digital footprints of the attackers, right? Spoliation of evidence, right? This case is the primary reference for spoliation in cyber law. Spoliation is the intentional, reckless, or negligent destruction of evidence that is relevant to a legal proceeding. The technical mistake was that the IR team prioritized business continuity, right? Getting the website back up over evidence prevention, which in this case, you need to find a great middle ground for this, just in case you get taken to court, because this was a legal issue. Anyway, they wiped the RAM and reinstalled the OS without taking a forensic image, meaning they destroyed, or in terms of terminology, spoiled the evidence, right? So the court's ruling was obviously the judge issued an adverse inference instruction, right? He told the jury, because the defendant destroyed the logs, you must assume those logs would have proven the defendant was at fault. And the result was virtually guaranteed a win for the plaintiffs, leading to a multi-billion-dollar settlement. Oopsies. Well, at least they got a settlement. Okay, well, now as we know what not to do, but let's say that we're with our business, we're the cyber lawyers, and we got past the governance and the prepare. Despite that, we still detected and identified a threat, and despite that, we still had to try and contain and eradicate it because it got through our defenses. And let's say we did that decently well, or now we're at this last phase, which is the recover and the improve. section, which the concept here is the clean room restoration, right? On the tech side, you no longer restore from potentially infected backups. You rebuild in an isolated environment from known good code. Excuse me. And then in the law perspective, you would have the notification phase, drafting disclosures that satisfy the 2026 Connecticut Forensic Reporting Law while mitigating class action risk. And then the mesh here would be the hot wash, turning a technical failure into a privileged lesson learned to prevent gross negligence claims. Frankly, I think that is self-explanatory. As a lawyer, you would have to make sure you have all your information in order, make sure that you have that nice draft and it's perfectly squeaky clean, make sure you protect your company's reputation as best as possible. Really, it wasn't your fault as a lawyer, but now you are the person who they are leaning on to make sure that at the very least, everything ends up the best it possibly could for the company at this point. Okay, one thing I do want to go over that we didn't really touch is the 24-hour ransom clock under the CIRCIA. We need to go over that, and then we would basically be done with incident response. It's a pretty basic, straightforward part of cybersecurity. Well, not the implementation, of course. That is down to the company and how the company operates and what kind of information they're handling and how severe the attacks would be or likely to be or and whatnot, right? All those details, those specifics are tailored. But essentially, the procedure, the parts that they would all have in common are pretty basic and straightforward. We can agree on that. The 24-hour ransom clock is the most high-pressure deadline in the incident response hierarchy. It represents a collision between a company's survival, getting data back, and national security, stopping the funding of adversaries. Under the CIRCIA, which stands for Cyber Incident Reporting for Critical Infrastructure Act, which reached full enforcement this year, the rules for paying a ransom are no longer best practices. They are federal mandates. The 24-hour reporting trigger. While a substantial incident gives you 72 hours to notify CISA, a ransom payment cuts that time down to just 24 hours. So that's what I was referencing when I first opened up this video. The clock starts the moment the payment is made. This isn't when the hackers ask for it, it's when the Bitcoin or the mineral leaves your digital wallet. And the logic is that CISA needs this data immediately to track the flow of money by following the wallet addresses. Federal agencies can sometimes freeze assets or identify the threat actor like the Salt Typhoon or the Lockbit groups before the money is launched. The conflict here, though, is that it creates a massive burden for the IR team. You are often still in the middle of the crisis, trying to decrypt files while the legal team is already under a countdown to notify the government. Sounds like a lot of pressure. And then the OFAC check, the strict liability trap. Before you hit send on that payment, the attorney must conduct a OFAC, or of Office of Foreign Assets Control check. This is where the law side becomes extremely dangerous because, first of all, strict liability. OFAC regulations are strict liability. This means if you accidentally pay a group that is on the U.S. sanctions list, like Evil Corp or groups affiliated with North Korea, you have broken the law. That I didn't know defense in 2026 does not work. You are legally responsible for knowing who is at the other end of every transaction. And of course, funding terrorism is incredibly illegal as well. And I'm pretty sure that goes without saying, right? This can lead to criminal charges, not just fines. And that is it. We have gone over majority of what is meant to be gone over in terms of incident response in both the tech aspect of cybersecurity and the legal aspect of cybersecurity. If you enjoyed today's video and you find it informative and you want me to go into a deeper dive on this topic, don't forget to like, comment, and subscribe, as I will continue to be doing these videos and research for probably the rest of my life. But anyway, I love you all so much. Thanks for watching and supporting me. I'll see you on my next one. Bye.